So this is the Business Law Chapter 19 notes. First thing is damages. A breach of contract entitles the non-breaching party to sue for monetary damages. In contract law, damages compensate the non-breaching party for the loss of the bargain, whereas tort law damages compensate for harm suffered because of another wrongful act. Types of damages are compensatory, which is to cover direct losses and costs. Consequential, consequential, which is to cover indirect and foreseeable losses. Punitive, which is to punish and deter wrongdoings, and nominal, which is to recognize wrongdoing when no monetary loss is shown. Construction contracts. The measure of damages in a building or construction contract varies depending on which party breaches and when the breach occurs. It varies depending on which party breaches and when the breach occurs. Breach by owner. The owner may breach at 3 different stages: before, during, or after performance. If it's done before, the contractor can recover only the profits that would have been made on the contract. If it's during, the contractor can recover the profits plus the cost incurred in partially constructing the building. If the owner breaches after, the contractor can recover the entire contract price plus interest. Breach by contractor. When the construction contractor breaches the contract either by failing to begin construction or by stopping work partway through the project, the measure of damages is the cost of completion. The cost of completion includes reasonable compensation for any delay. Example, think about missing an assignment or showing up late to class. There are consequences in the same analogy. So that's one way to think about it and understand it better. If the contractor finishes late, the measure of damages is the loss of use. There are other damages such as consequential damages and punitive damages. And nominal. Actual damage or financial loss results from a breach of contract and only a technical injury is involved. The court may award nominal damages. Rescission is essential, an action to undo or terminate a contract to return the contracting parties to the positions they occurred prior to the transaction. Reformation, an equitable remedy used when the parties have imperfectly expressed their agreement in writing. It allows a court to rewrite the contract to reflect the parties' true intentions. The require of quasi-contract. The party has conferred a benefit on the other party. The party conferred the benefit with reasonable expectations of being paid. The party did not act as a volunteer in conferring the benefit, and the party receiving benefit would be unjustly enriched if allowed to retain the benefit without paying for it.